Audio check. Right, good afternoon, everyone. Just before we start on the cross-examination, as we said we would, we've had a think about the BEIS Evaluation of Greenhouse Gas Emissions Policy Appraisal Evaluation document. Our view is that this can probably be dealt with by written submissions and then obviously any remarks in closing. I was conscious that there were a couple of requests to quite reasonably give a certain amount of time to comment on this. I think the best we can do is any comments in on this, please, by Friday, 24th of September. So we're sitting on climate change this week, then we have Greenbelt, landscape and local residents for a week. Then the inquiry isn't sitting for a week, and at the end of that week, Friday, 24th September, any comments back on this document, please. I'll ask the programme officer to send a note out to the other all 6 parties who I'm conscious are not in the physical or virtual room, but Friday, 24th of September for that one, please. Okay, unless there are any other pressing housekeeping matters, Mr. Humphreys, over to you.
Dr. Hinnells, good afternoon.
Good afternoon, sir.
Dr. Hinnells, I'm going to start with just a few introductory points in a format that I've adopted with other witnesses, so forgive me, and then we'll get on to the substance of your evidence. You, and indeed Ricardo, were not advising, obviously, were you, in the period leading up to the determination of the application?
That's correct.
I think it was another firm. I think it was Jacobs who were advising at that time. Is that right, as far as you know?
I believe so. But
I'm not going to hold you. Yeah. I'm not going to hold you to it. In the officer's planning report, the officers did come to a conclusion on the climate change issue. I'll take you just very briefly to that. They came to a number of conclusions, but on this one I'll just take you to one. So CD 411, please. And turn to PDF page 42. And that page, go right to the bottom. It's part of the climate change section, and at the bottom of PDF page 42, there's a subheading summary. Do you see that?
sorry, CD?
Sorry, it's CD 411, 4.11. There's no need to rush. Take your time.
I've got the committee report. Is that what you're...
That's it.
That's right, yes. Okay.
And within that, in the PDFs, what I'll do generally is refer to PDF pages, because
Sure.
I think we're all looking at PDFs. Could you turn to PDF page 42? Yeah?
Yeah.
And towards the bottom is the summary of what the officers concluded. And just take you to that first sentence under the subheading summary. It says, greenhouse gas emissions arising from the proposal, including those arising from flights and other sources, are unlikely to have a material impact on the ability of the government to meet its climate change obligations. First point is that test, material impact on the ability of the government to meet its climate change obligations, is exactly the test that you advocate, isn't it?
Mm-hmm.
Could you say yes, just for the
Sorry,
record,
yes.
rather than...
I beg your pardon,
I think
yes.
I know what you, I know what you mean,
Yes.
but it just makes it clearer for those
Sorry.
taking a note.
I beg your pardon, yes.
That's all right. And we can see there that the council's own officers and consultants clearly formed a different view, a different conclusion at that time, obviously, from you.
Indeed.
Okay.
Except that you are right to point out that it was at that time,
Of course.
and that time being prior to the government decision to include aviation within the sixth carbon budget and the decisions on the sixth carbon budget.
Yes. But of course, the net zero target, of which the budgets are simply a means of delivering, they're the 5-yearly means of delivering the target, was known at that time.
The sixth carbon budget was
No,
not known
not
at
the
that
sixth
time.
carbon
The
budget,
fifth carbon
but
budget
the
was known.
net zero was known about, wasn't it?
It was. The law had been changed, yes, but the treatment of aviation within net zero was let's say, ambiguous.
Okay. And that brings me on, in a sense, to a slightly different point. Your still introductory point. Your reliance now on the sixth carbon budget. We know too that you gave evidence at the Stansted inquiry, and your case there, your proof of evidence isn't a core document, but obviously I've seen it, it's a public document, argued that very little weight should be attached to the MBU policy, amongst other things, because it's out of date, and that the development would almost certainly adversely impact the UK's ability to meet its 2050 net zero target. Do you remember those were two of the themes in your evidence? Now, you sought in your evidence in chief to distinguish the decision of the inspectors in relation to Stansted from the position before these inspectors.
Mm-hmm.
Yeah. And you did that by reference to the sixth carbon budget. Yes?
Mm-hmm. Yes.
Thank you. So can we agree that all the other grounds, other than the sixth carbon budget, all the other grounds that you then raised and currently raise about the status or the weight to be attached to MBU were considered by the inspectors and rejected?
That's a difficult one. I don't think we can agree that, and if I can unpack why. The sixth carbon budget recommendations, unfortunately, came out...
Yes. I've put aside sixth carbon budget. I've said that clearly you are distinguishing that. I'm looking at all the other arguments that aren't sixth carbon budget.
Yes, at that time, the recommendations on aviation were advice rather than policy. And we have to clearly discriminate between advice and policy. And as we've gone forward, then the advice has increasingly become policy.
Dr. Hennels, you're in danger of simply sort of talking around the subject. It's quite a specific question. I'm trying to narrow issues, Dr. Hennels.
Sure.
That's what I'm trying to do. Apart from the sixth carbon budget, which I accept post-dated Stansted, all the other arguments that you currently made were made at Stansted and were rejected, weren't they?
They are currently before an appeal.
No, I didn't ask you whether they're currently before the appeal.
They were...
Really, Dr. Hennels, really try and focus on the question.
Yeah, let's try for a yes-no answer and then qualify
Sure,
it. So I think the question is quite specific, but by all means qualify the answer.
Sure.
Of course.
The inspectors were not persuaded by those arguments.
Okay. I'll settle for that. And the only reason why, from your evidence in chief, I think you say that the current inspectors should be persuaded differently is because of the sixth carbon budget becoming a statutory instrument.
The sixth carbon budget becoming, the sixth carbon budget becoming a statutory instrument, and the inclusion of international aviation shipping, the acceptance of that recommendation from which was up till that point only advice, became policy.
So those are the two things, if you like, they're wrapped up. The sixth carbon budget and the inclusion of aviation within it are the things that you say make the difference.
And although Jet Zero has many weaknesses, as we've discussed, it is a step forward in recognising that aviation needs a new policy environment to address the objectives of the sixth carbon budget and the inclusion of IAS. So there are three things, if you like. There's the sixth carbon budget, the inclusion of IAS, and the beginnings of a policy journey, which we're hopefully close to completing.
Now, much of your evidence in chief, I would reckon about 80%, perhaps more, was focusing on your criticisms of the Jet Zero consultation. Now that's, obviously, as we know, just a consultation document. I'm going to touch on it later because it is a consultation document. It is material to that extent. But I'm going to focus first on the legal and policy framework that currently exists rather than emerging policy. Okay?
Okay.
And I'm going to go through a lot of documents and give references. I'll give the references. If you wanted me to go to the documents, just ask. But just to try and expedite time, I'm not always going to take you to all of them. Is that okay?
Okay.
All right. So let's start with the legal framework within which the inspectors are taking the decision. And let's start at the very highest, most general of levels. And the legal framework, in effect, started at an international level, didn't it, with the United Nations Framework Convention on Climate Change in 1992. It was one of the three conventions signed at Rio. Yeah? Mm-hmm. And I'll give the reference so that inspectors or anyone else have it, but we have it as CD 9.19. And it was in Article 4 of the Framework Convention that the various, very high level at that point, commitments were set out, weren't they, for the contracting parties?
Mm-hmm. Yes.
Thank you. And then, because that was a framework convention, what's happened since then is that there have been a series of further sub-agreements and protocols that have put flesh on the bones or rolled things forward. And they obviously include the Kyoto Protocol, the Paris Agreement, and obviously Doha and a number of others. We broadly agreed on that.
Yes.
The Kyoto Protocol, 1997, CD 9.20, amongst other things, made it clear, didn't it, that aviation emissions, so it's Article 2, sub 2, aviation emissions are to be dealt with internationally through ICAO, the UN's International Civil Aviation Organization.
I don't think that, I agree, but I don't think that in fact, that doesn't preclude the opportunity for additional policy at national level.
Didn't say it did. Just saying that at an international level, as far as the Framework Convention and its sub-agreements are concerned, aviation is to be dealt with internationally. And there are obvious, I guess, Dr. Hennell's reasons for that is that aviation obviously happens
Sure.
within, but also between countries, and international cooperation's important, isn't it, to deal with things like leakage? You know, you clamp
Sure.
down on something somewhere and it just moves to somewhere else.
Sure. Yes, absolutely.
It was the Kyoto Protocol, Article 3, which was looking at a commitment period of 2008-2012 that set out in its Annex B what were then national commitments for each country. So at that time, Kyoto, and the same at Doha, the agreements themselves said what the commitments had to be for each country for each period. Do you recall that?
Yes.
Yeah. It was also the Kyoto Agreement, wasn't it, Annex A, that identified the 6 greenhouse gases that the Framework Convention and its various other agreements relate to, the Kyoto greenhouse gases.
Yes.
Yeah. And we'll come to it later, but that's why the Climate Change Act in the UK refers to 6 greenhouse gases. Those are the internationally agreed Kyoto gases, aren't they?
Mm-hmm. Yes.
The commitments at Kyoto, the national commitments, were rolled forward at Doha, which actually wasn't ultimately ratified for a very long time. But by the time of the Paris Agreement, which we'll come to in a moment, the approach changed, didn't it?
Indeed.
And the contracting parties moved away from the agreement setting commitments, and it moved towards, and we'll touch on it in a moment, nationally determined contributions.
Yes.
Yes? So let's, and you're right to point out that aviation, of course, nationally can be brought within requirements, but as far as the Framework Convention was concerned, because of Kyoto, aviation was always treated as being external to the commitments, including, actually, the Paris nationally determined contributions.
Indeed, yes. Except that, and I do have to interrupt you there, and you might be going here anyway, but obviously Paris was talking about a temperature goal.
We'll touch on that.
Okay.
Now, we'll come to Paris just so that you can get it ready at CD 926. And you touch on this yourself in your proof of evidence, paragraph 42. And you say in paragraph 42 that it is a legally binding international treaty, which is obviously right, but I suspect that we can agree, can't we? It's, sorry, I'll let you get there.
Sorry, paragraph?
It's just, I was suggesting you had the Paris Agreement open, which is CD 926.
Yep.
So we'll look at that in a moment, but in your proof, paragraph 42, so your written proof of evidence,
Yep.
which is page 16, all the proofs I'll refer to the paper pages, all the other documents, the PDF pages, because I only have them on PDFs, and I only have the proofs in paper.
Yes.
You say it's a legally binding international treaty, and again, I think we will be able to agree on this. It's legally binding at an international level, isn't it, between the contracting parties, but because the UK is a dualist legal system, it only creates legal rights within the UK to the extent that it's incorporated. That's why it's sometimes called an unincorporated international
Yes.
treaty. We're agreed on that, aren't we?
I'm happy to accept that.
You're not a lawyer. I'm not expecting a legal answer, but you made the point it was legally binding. I just wanted to make sure that I understood what you meant. You're not suggesting different to what I've put to you.
I'm not suggesting different, no.
Okay. No, we're all probably pretty familiar with Paris, but let's light touch just run through some of the points. There's a PDF, page 5. Article 2 and Article 2(1)(a), that's the very well-known long-term temperature goal, isn't it?
Yes.
And the Paris Agreement obviously recognizes, however, that because that is global and it is a temperature goal, that in order for individual contracting parties to work towards an international goal, you have to have some set of national commitments, and that's what we get in Article 3, isn't it? Just below, towards the bottom of that page. This is the section on nationally determined contributions. So Article 3 introduces the idea of nationally determined contributions and points to other articles. And Article 4, which is the top of PDF page 6, this is where you heard me just now refer to Article 2 as the long-term temperature goal. You can see in the first line there, this is where we get that from. This is what the Paris Agreement itself calls the 2 degrees and the 1.5 degree, the long-term temperature goal. And I won't read it all out, but you can see 3 or 4 lines from the end there. The aim is to achieve a balance between anthropogenic emissions by sources and removals by sinks, and those terms are defined, of greenhouse gases in the second half of this century. So people sometimes incorrectly suggest that the Paris Agreement says you have to have net zero by 2050. The Paris Agreement doesn't actually use those terms.
No, sure, that's a UK interpretation of the Paris Agreement.
It's a UK
commitment.
A UK target,
Yes.
a UK commitment, if you like, but that's what Paris actually says there. And then Article 4(2), each party shall prepare and communicate and maintain successive nationally determined contributions that it attends to achieve. And then there are lots of further things around that I won't take you to, but insofar as there are commitments on individual contracting parties, they're based around that central commitment, aren't they? Article 4(2), that you have to prepare and maintain nationally determined contributions.
Indeed.
And when the UK was part of the European Union, it made its nationally determined contribution through the EU, didn't it? I think Latvia was the president of the council at the time, so it's technically Latvia that made it on behalf of the EU, but the UK's contribution was part of that, wasn't it?
Correct.
Obviously, now we've withdrawn, the UK has declared its own nationally determined contribution, and we've touched on that. Insofar as the Paris Agreement talks about concepts of equity in Article 2 or Article 4, or developed countries' responsibilities in Article 4(4), those are, of course, to be reflected in their nationally determined contributions. There's no obligation above the nationally determined contribution, is there?
There's only the obligation that International Maritime Organization and International Civil Aviation Authority have in terms of international
Yes.
emissions. And obviously, doubtless this is where you're going, that's why to draw those obligations from ICAO and IMO into the UK target has taken some thought.
Now, so we've looked at the international framework that then gets us, in terms of the legal obligations, to the Climate Change Act 2008. And although Kyoto was 1997, I think it was only finally ratified in about 2005, and Climate Change Act 2008 was shortly after that. And we have that at CD 9.2. Worth turning that up because we can look at a few things there. But the Climate Change Act is it
Sorry,
not?
CD 9.2.
9.2. 9.2.
I've got CD Climate Change Act as CD 9.046, but that's okay.
Oh. Okay. We can go to that one. What have you got it as? I think that's the original version. Is it 046? 46. It doesn't matter to me.
Yes, that's the unamended version.
Okay.
Sorry, which are we on? I'm on 2008, CD 9002.
I looked at zero. For my purposes, that's enough. But
Okay.
But I think Mr. Taylor and Dr. Hennels have correctly said that was the unamended version of the Act, because I don't know what the amendment is. I didn't really think about it. But I think the amended version, sir, is 9.4046.
Okay, thanks.
And so we've got two. Mr. Taylor has played a cruel and cunning trick on me. Dr. Hennels, for these purposes, I don't think it matters. We know that the 80% has been changed to 100%.
Yes.
If there's anything else that you think has changed, we can get the versions of the Act changed. So the Climate Change Act 2008 is, of course, the UK mechanism, isn't it, for delivering the UK's international obligations under the Framework Convention and Paris and everything else. It's our mechanism to the extent that we've incorporated international treaties. This is the prime act that does so. And we know in section 1.1 of whichever version of the original act that we look at, that section 1.1 sets out the duty. Originally, the wording there said 80%. It now, since the middle of 2019, says 100%. But this is the duty on the Secretary of State to ensure that the net UK carbon account for 2050 is at least, now says 100% lower than the 1990 baseline. 1990 baseline because that was 2 years before the Framework Convention in 1992. That was the base year they were looking at. And a number of concepts there. The net UK carbon account, that's a defined term, isn't it? I'll give you the reference, but we don't need to look it up unless you want to. That's defined in section 27, and it's the UK emissions of targeted greenhouse gases. Yeah?
Yes.
And if we want to know what targeted greenhouse gases are, we're told that in section 24, and that's the 6 Kyoto gases. And section 92 also defines the term greenhouse gases, and it's the 6 gases. Now, side point here, the non-Kyoto greenhouse gas effects, i.e. contrails, cirrus clouds, those things, are not included in the net zero target, are they? Then
Correct.
They're not Kyoto greenhouse gases.
Correct.
Still back in section 1.1, and it's a point you touched on in your evidence in chief, and it's an important point. In section 1.1, there is a legal duty placed on the Secretary of State, isn't there? A duty to ensure that the net UK carbon account, the 6 greenhouse gases, for the year 2050 is at least 100% lower than the baseline. And the inspectors have to assume, don't they, that the Secretary of State will comply with his legal duty.
Yes, they have to assume that. On the other hand, at the moment, the Secretary of State is reliant on things that we showed were very difficult to deliver, either because they technically don't exist at the moment or because the market to encourage them doesn't exist.
You're now getting to Jet Zero consultation and means of implementing things. I'm still on a pretty basic legal point. The inspectors have to assume, don't they, that the Secretary of State will comply with the law. By whatever means the
yes.
Secretary of State thinks appropriate,
Yes.
the Secretary of State will comply with the law. Yes? If we just look at section 4 now, section 4 is the section that deals with carbon budgets. And that sets, section 4.1, 2 duties on the Secretary of State. The first is to set for successive 5-year periods a budget for the net UK carbon account. We know what that is.
Yes.
And the second is to ensure that the net UK carbon account for the budgetary period does not exceed the carbon budget. Yeah? Do you see 4.1b? Do you see that?
Yes.
And again, the inspectors have to assume, don't they, that the Secretary of State will comply with the law. The inspectors can't assume that the Secretary of State is going to break the law.
Let's take that as read for now.
Well, no, don't want to take it as read. I just
Well,
want to understand.
it wouldn't be the first time that a minister's been found on the wrong side
Sorry?
of the law. It wouldn't be the first time that a minister's been found on the wrong side of the law, would it?
Oh, that might be the case. But the inspectors, in taking a planning decision now,
Yes.
can't assume, can they, that the Secretary of State is going to break the law.
They can't. Let's take that. Let's work with that hypothesis.
No, I'm not happy to work with it. They have to assume that, don't they? And unless you're going to tell me some sort of surprising new legal concept that says that planning inspectors are allowed to assume that the law will be broken by the Secretary of State.
Let's assume that the Secretary of State is being reasonable and that he's fulfilling his duty under the Act. But at the moment, that there's still a long way to go for the Secretary of State to fulfil that duty.
Oh, you may have, and we may need to come to them, arguments about whether or not you think that there's more that the Secretary of State needs to do. Okay. But the inspector should assume that to the extent it is necessary to do them, the Secretary of State will do them because he is duty bound to do them. under section 4.1.
Yes.
Yeah. We also know from section 5.1b, that the carbon budgets have to be set to meet the 2050 target.
Yes.
And we also know, of course, that the carbon budgets from the sixth carbon budget will be set to meet the UK's new nationally determined contribution for the same period.
The national determined contribution is for 2030 and doesn't quite align with the UK carbon budget.
You're right, the periods for nationally determined contributions and budgets, but the intention is
the direction of travel is the same.
The two are aligned, and therefore, insofar as the UK government has international obligations in relation to its nationally determined contributions, those are delivered by a combination of sections 1 and 4 of the Climate Change Act.
Yes.
For what it's worth, but clearly in a sense things have slightly moved on, emissions from international aviation under the Act do not count, do they, as emissions from sources within the UK, section 30 of the Act.
That's where the headroom arrangements came
Yes.
in, with the requirement for the Secretary of State to make arrangements for headroom, or to make a decision on international
Correct.
aviation in
So
2012.
section 30 is, in a sense, replicating Article 2.2 of the Kyoto Protocol. In other words, Kyoto took international aviation outside the emissions. Section 30 did the same in the Climate Change Act.
Yes.
Yes? But, section 10 to I, that's the headroom, section 10 to I of the Act, then said when the budgets are set, this is the UK government going, in a sense, beyond the international conventions, when the budgets are set, we in the UK will set our budgets taking account of an allowance for international aviation.
Indeed.
And that, in a sense, was the foundation, wasn't it, of what was at one point called the aviation target. It's also called the planning
The
assumption.
planning assumption, yes.
And I think the CCC first advised on what they called the aviation target at that time in 2009. That's CD document 9.3, PDF page 9. And so the CCC said, right, we have a duty, I'll come to this in a moment, we have a duty to advise on aviation, and we think the 37.5 figure is the figure you should take into account.
Yes.
Section 32 of the Act created the CCC, didn't it? It's PDF page 24 if you want to look it up. Created the CCC, and then the sections that follow gave the CCC a number of specified functions. So they're not just at large able to do quite whatever they want. They have a number of statutory functions, and Section 33 sets out their duty to advise on 33 on the level of the 2050 target, and 34 is they have to advise in connection with carbon budgets. We know about that. 35, advice on emissions from international aviation, and they have to report on progress and so on. And 38 actually is they there's a sort of catch-all duty to provide advice or other assistance on request, so the Secretary of State can ask the CCC to advise on particular things. And there we can note that obviously they haven't been asked to advise on this appeal.
Yes, understood, yes.
Okay. So with that sort of international context and then the national legal context, we get down to the carbon budgets, because those are also part of the legal framework. And there've been the first to fifth carbon budgets. We don't, I think, have those as CDs. I think 1 to 3 were all done in one go, weren't they? There was a single statutory instrument. And then there was 4, then there was 5, and we now have 6. And in the first 5, the CCC's advice on 37.5 megatons CO2 planning assumption, that headroom was allowed, wasn't it? So those budgets were set with that headroom allowed.
Yes.
And that headroom was allowed. I'll only raise this because one of the BAN-CC witnesses seemed to query this. That was the headroom allowed in both the 4th and the 5th carbon budget, wasn't it?
It was, yes, I believe it was, yes.
I mean, we can look at the CCC's letter that confirms that.
There was a CCC letter that advised a revision to 30, but it was advice, not policy.
Yes.
And I think it was later than the 5th carbon budget, if I remember correctly.
Now, those carbon budgets and the planning assumption for those carbon budgets, you say 37.5 is out of date, but for those carbon budgets, the 4th and the 5th carbon budgets, they have not been amended. So although you say they're out of date, those are the law.
Indeed. When you say they've not been mended, I'm not sure that they are particularly broken, other than that we're a way off dealing with them, meeting them.
Well, they're still, for the 4th and 5th budgets, they're still in the future, but
Indeed.
they haven't been amended.
Indeed.
And obviously, the inspectors need to have regard to that, don't they? That those are the budgets, those were the planning assumptions for those budgets, and that nothing has changed.
Yes, I accept that point.
I want to come now to slight tangent, forgive me, but it's just the most convenient place to pick up this point, which is some points have been made. You kind of made the point, and others have made the point about UK performance against the budget. So, slight tangent, as I say, forgive me, but could you just look at CD 9.78?
Is that 9.078?
It'll be exactly the same. Sometimes the zeros are put in, and sometimes not, but yes, it's... This is the updated energy and emissions projections 2019. And what I'm looking to do is just get you to help me to explain to the inspectors where we are against performance, in terms of performance against the budgets. Do you have it?
I do, yes.
And just start on PDF page 5. And I'm just looking there at the executive summary, and the 3rd and 4th paragraphs, I hope we'll be able to kind of agree this. The energy and emissions projections, that's what this document is, are one way we monitor progress towards the UK's legislated targets. Between the baseline and 2018, the UK cut emissions by, and the numbers are given 43%, we project they will fall a further 24% in 2040. And then this, each year, BAIS updates the projections to incorporate new evidence, policy developments, and methodology improvements. And it's important to understand what the EEPs are. They're annual things in which government plugs in each year new policy initiatives when they're sufficiently well developed and reports back on the effect that those policy initiatives have on future budget forecasts.
Yes.
And if we just go to page 12, that's the section on UK emissions projections. And there are 3 bullet points at the top there. I'll just touch on the third one. I mean, just scan through in case there's anything else you want to look at. But the third one I was going to draw your attention to. The projections show shortfalls against the 4th and 5th carbon budgets of, and then the figures are given. The projections take account of policies that have been implemented, adopted or planned, and where the policy design is sufficiently advanced to allow us to quantify impacts. And then there's a reference to footnote 19, which says that some of the policies in the Clean Growth Strategy 2017 have not yet reached this stage. We will include these in future EEPs. So again, so the inspector understands what these are. This is a kind of a rolling thing where government, as soon as policy is sufficiently well developed, it kind of plugs it in and it sees what's happening in terms of the projections. And so what we get when we turn to page 15, which is...
Sorry, 15.
15, PDF page 15. Which is the table that's been reproduced a few times, and people have drawn attention to the line EEP 2019, and you can see results versus budget with reference case and results versus budget with inclusion of Clean Growth Strategy policy proposals, and then again reference to footnote 2. And what we can see is that for the past carbon budget, CB1 and 2, we met them. For CB3, the current budget, which ends in 22 next year, we're currently forecast to meet it. But for future budgets, which haven't started yet, clearly there, it's reporting we don't yet, but the reason for that, as we know, is that policy is continuing to develop. So, for example, decarbonising transport and all the policies we're talking about just aren't in this, are they? And various other strategies just aren't reflected in this 2019 projection. And so, I know you don't draw such a crude conclusion, but others may. One can't simply look at this and say, oh, well, we're not going to meet the budgets, because the future ones just don't include all the policies, do they?
Sure.
And now, can we move, because I know this is of interest to you, to the 6th carbon budget. The 6th carbon budget report did a number of things. I mean, it explored various scenarios.
Sorry, do you mean the CCC 6th carbon budget report?
Sorry, what did I say?
You just said the 6th carbon budget report.
That's what I'm, the 6th carbon budget report from the CCC.
The advice report rather
Yes.
than, yes.
Yes, the advice report rather than the budget itself. I do apologise if that wasn't clear, I'm sorry. So, which we have as CD 9.66, explored various pathways, including balanced pathway and widespread innovation and others. The inspectors will have seen all of that. And it presented government with some recommendations, as you said, some advice, and perhaps it is worth looking at this. So I think it's CD 9.66.
So 9.066 is the aviation section of the entire budget.
Are you happy to look at that? I mean, because
Yes,
that
that's fine.
actually has some of the. So there was the overall
Yes.
report, and 966, as you rightly
It was an
pointed out, is the
enormous
aviation.
piece of work, and it covered the whole economy. And of most interest here will be the aviation section of that report, which is,
Which
as you
is
say,
the bit I've taken you to, I
9.066.
think.
Yes.
And let's just look at PDF page 29, because I think that's the recommendations. Yeah. And we can see in the table there, P8.1, that there are a series of recommendations. The first was formally include international aviation emissions within UK carbon targets when setting the sixth carbon budget. And that has been adopted. You made the
Indeed.
point earlier,
Yes.
the difference between advice and policy. And that,
Yes.
it's only advice here, but we know that that has been adopted. Work with ICAO to set long-term goal for aviation consistent with Paris Agreement. I think the government is in fact doing that. It's not particularly germane to the point I want to make at the moment, but government
Sure,
is.
it's quite important because, as you say, the aviation is outside the nationally declared contribution and sits inside the work with
Yes.
ICAO. So it's important that ICAO has a target. At the moment, ICAO's target comes under criticism because it's only net zero growth. In other words, any increase in aviation activity from now should not lead to an increase in emissions from now, but it doesn't get us down to net zero. It leaves us a long way off net zero, which is why the
We'll come back to
ICAO
it.
objective needs to be
Yes.
reviewed.
We'll come back and touch on Corsia a little bit later, perhaps. The third one, commit to a net zero goal for UK aviation as part of forthcoming aviation decarbonisation strategy, international aviation reaching net zero by 2050. This is in effect part of the decarbonising transport plan.
Indeed, yes, and the aviation decarbonisation strategy should follow the Jet Zero consultation.
Yes. And there should be no net expansion of UK airport capacity unless the sector is on track to sufficiently outperform its emissions trajectory and can accommodate additional demand. That one has not been adopted, has it?
It hasn't.
And we can come back and touch on some of these things, but not. And then for non-CO2, monitor non-CO2 effects of aviation, set a minimum goal of no further warming after 2050. Research mitigation options, consider how best to tackle non-CO2 effects alongside UK climate change targets without increasing CO2. We'll again come to non-CO2 later, but non-CO2 has its own sort of somewhat unique position. It's not part of the target. It's being looked at, isn't it, internationally, and but it's very difficult to quantify it, and we'll come to this later. But it's very
If we're coming to it later, then fair enough. But it's something that the International Panel on Climate Change first reported on in 1999. So it's an issue which has caused a lot of concern on all sides, non-CO2 warming, because it is difficult to quantify. Part of the issue is the time period over which you do the quantification. I think the science on that is certainly improving, and David Lee, who is at Manchester Metropolitan University, has done a lot of work on that for DFT to help unpack that science. and there was a very important publication of his in Atmospheric Science at the start of this year, and he is the lead author of the Aviation chapter of IPCC Working Group 3, which will report in March of next year.
Thank you.
So there is uncertainty, there is acknowledged uncertainty.
I will come back to it, honestly. But,
Okay, right. But it is an important subject not to get dropped.
It's a subject we will touch on. Now, we know the government made it very clear, didn't it, in its press release on the sixth carbon budget back in April, that whilst it had accepted inclusion of aviation in the sixth carbon budget and the total figure for the sixth carbon budget, it didn't accept other recommendations. I think your own proof of evidence makes that absolutely explicit that they didn't.
Yes.
And they, in particular, didn't accept the need for a capacity cap. And here I'm going to, a bit like we with carbon price and carbon value, I'm going to try to be precise about terms. We need to be careful here, don't we, to be precise about demand and capacity. Those
Indeed.
are obviously not the same
Indeed,
things.
yes.
And so here, the recommendation of no net expansion of airport capacity was rejected. That's not possible.
I wouldn't say they've rejected it, they just haven't accepted it yet.
Well, you say yet. They
No,
have
well,
not accepted it.
They've not, well, I would stick with the yet, so that they've not accepted it yet. And the reason I say that is because neither have they accepted the recommendations about changes in diet.
Okay.
And the consequence, if you stick with the target, which is what they've done, and you don't include some of the measures that were part of the package, you have to include other measures from some other part of the economy to make up the emissions savings that would have been made had you accepted those parts of the package.
Can we agree that capacity caps do not form part of current government policy?
Absolutely, they've been silent on that, yes. Well, no, they've been more than silent on that. You know, we've seen what they've said in the consultation paper at footnote 39.
And the direction of travel in decarbonising transport itself. We'll come to that as well.
Decarbonising transport didn't include any commitments.
Let's not
around
jump
MBU.
ahead.
Okay.
We'll come to all of that. Again, still on sixth carbon budget, we can agree as well that the sixth carbon budget does not include any sub-budget or sectoral targets for aviation.
Correct, and that's the implication. Well, the sixth carbon budget does not yet include any replacement for the planning assumption of 37.5. There is no sub-target at the present time.
But again, we can only operate within the situation of government policy that we know now. So for these inspectors, we can agree
yes.
that there is no sub-budget or sectoral target.
There was a trajectory that government said it would continue to monitor.
Can you just answer that one with a
yes,
yes, no? There is no sectoral target or sub-budget for aviation in the sixth carbon budget?
correct.
Okay.
And that's one of the weaknesses of the current consultation, that it doesn't, at the present time, lay out how aviation contributes to the sixth carbon budget.
Okay. But there you're touching on, as you do with much of your evidence on the Jet Zero consultation, you're touching on, we'll come to this, not current government policy, but the formulation of future government policy.
There is a trajectory that is foreshadowed in what is a consultation
paper. What you're focusing
paper.
on in this point is not current government policy, but what you say is future government policy. What you say government policy should be or needs to be.
That's not what we did this morning. What we did this morning was unpack we didn't say what it should be. We didn't say what it needed to be. What we said was how the consultation that government is currently going through is inadequate to meet the duty that the Secretary of State has to meet the obligations of the 6th carbon budget period and the net zero in 2050.
But that's a consultation. Presumably you, Ricardo, or the Council will make representations on that consultation?
We as Ricardo won't, because
Right,
we've more often than not been advised.
Clients.
Yes. We have advised government, so the predecessor to the ATA Hollande paper was a Ricardo paper, so we know the assumptions that go into those.
Government will take all those representations into account and formulate its policy. You speculate that that policy might be subject to judicial review in your evidence in chief. Obviously that's speculation, but it's not the role of these inspectors to advise government or indeed anybody else on the formulation of future government policies, is it?
No.
No.
No, and nor is it, well, I mean, the Council can respond to a consultation, but it's not the Council's place to be an advisor on policy, and BAL can respond to consultation as well.
Now, the next piece of, insofar as, you made the point about trajectories, insofar as the CCC looked at a trajectory towards the 6th carbon budget and used the 23 megatons CO2, in fact, as part of our overall evidence, we have looked at that as a sensitivity test, haven't we?
Yes.
The next area of legislation I just want
If
to...
you're moving on,
Yes.
I do want to put a rider on that. So I don't see any relevance in using 23 megatons as a sensitivity test, in all fairness, because that's an intermediate number. The sensitivity test should be against net zero, not against 23. 23 is not relevant. So what the relevant number is now, post 6th carbon budget, post the decision to include IAS, is net zero.
Okay, so
I don't see any relevance whatsoever in a
just
sensitivity
so
test
that
against
I'm
23.
clear on this, and what role you are saying that the 6th carbon budget plays. I thought you were saying that the 6th carbon budget was important and that the 23 megatons had been projected as part of that, but what you're actually saying is the 6th carbon budget isn't important?
No. 6th carbon budget is not relevant here. What we're talking about is 2050 and the 21 megatons of carbon in 2050.
I was talking about the 6th carbon budget and the fact that the CCC's report looking at that had used a figure of 23. We agreed that that wasn't...
Sorry, that's 23 in 2050.
Right,
Yes.
and 31 in 2030, I think.
Yes, but my point is that using a gross emissions number as a sensitivity test when you need to get to a net emissions number
Right.
is not the right number.
Okay.
So if you're going to do a
All right.
sensitivity test, either for the 6th carbon budget period or for 2050, that sensitivity test should be against the net number, not against the gross number. Is that clear?
It is. I mean, I don't know that it's accepted, but insofar as the CCC has looked at two figures, the 31 megatons and the 23 megatons, we have looked at the contribution of the appeal proposal against both of those sums. Now, you may say that's not worth doing, but it has been done, hasn't it?
It has been done. I don't dispute that. It has been done.
Now,
But as I say, I don't see its relevance.
No,
It's the net number is the important one.
I mean, that's maybe where you and we just don't agree, and that's absolutely fine, as long as we've identified where the differences are. The next piece of legislation, just to touch on, is the UK's emission trading scheme, so the Greenhouse Gas Emission Trading Scheme Order 2020. And we have that as CD 9.36 or 036. You may have it as...
Sorry, my computer goes to sleep and I have to wake it up.
Don't worry, I know the feeling.
It doesn't get as excited as I do about these subjects.
You need to get out more.
That's probably true, sir. Sorry, 9?
9.36.
9.36. Yes.
Now, obviously, on the UK's withdrawal from the EU, or more accurately, I suppose, the ending of the transitional arrangements, the UK ceased to be part of the EU emission trading scheme, and its own emission trading scheme, which was enacted in 2020,
yes,
took effect at the beginning,
yes,
of this year. And it's one of, isn't it, the mechanisms which government intends will deliver future carbon budgets, not just actually for aviation, but other sectors as well.
Indeed, yes.
And again, if we, what I'm going to try and do, Dr. Hindles, is, again, kind of light touch, go through it. If we need to really look at something, hey,
sure,
we can dive in. But I'm very keen that the inspectors understand exactly what the legislation is and how it works. So if we just want to dive in, if you go to PDF page 13, that's really, in a sense, the starting point from my perspective. This starts to set out in Part 2 the basic elements of the UK ETS, and it's set up in Regulation 13. And I suppose the thing that it's worth noting here, so Regulation 16.2b, that the UK ETS focuses on aircraft operators. It's not a system that focuses on airports,
sure,
or airport operators. It focuses on aircraft operators. And if we kind of roll on Regulation 18, 19, and 20, and beyond that, it sets up a system of allowances, and the allowances, an allowance allows you to emit 1 ton of carbon dioxide equivalent, and the equivalent word is because some of the other 6 Kyoto gases have a slightly different value.
Indeed.
So you create a
yes,
carbon dioxide equivalent, don't you?
yes,
And you have allowances, and you have Regulation 20 caps. So an overall cap will be allowed, and these allowances, of course, are not just for aviation, are they? They're for all of the sectors within the ETS.
yes,
And regulation for the base scheme years, Regulation 22 sets out what the caps are. The base for the scheme years sets out their various values. Sorry, it's 23 I want to look at. And 23 tells us that the allowances may be traded, and this is the point. So the different operators are given or are able to purchase allowances, and they have their allowances, and then they're allowed to trade those with each other, depending on how many they need in any particular year. And we touched on it this morning, isn't it? It's that trading, you made the point that, look, the carbon price is an output from the trading.
Indeed, yes.
It's that mechanism, it's the regulation 23 mechanism, isn't it?
Yes.
The trading, which, as people buy and sell allowances, because, look, I want to expand, I need more, and you've managed to cut your
Indeed.
emissions, you need less.
Indeed, indeed.
And so you sell me one of your allowances.
Yes.
That's where we get the carbon price from.
The carbon price and not the carbon value, yes.
Yes, that's why I said, I hope I said, I think
Yes,
I did, carbon
yes,
price.
yes.
And that's the point, not the carbon value.
Well, that's right, but the carbon value is something that might be borne in mind, for example, to reduce the number of permits that can be traded or that are available to purchase.
Yes.
So, like a game of musical chairs, you take away some chairs.
Yes.
Except you have a lot more chairs and a lot more permits, and you may take away some chairs, and therefore that drives the price, not the value, up.
Yes.
And one option is that the price becomes equivalent to the value.
Yes.
But there are other options.
Sorry, as you said very clearly this morning, that would require an intervention of policy to make
Yes.
that happen.
Yes.
And there you're talking about an evolution of future policy, which currently does not exist. The inspectors can't
Except it
look
was
at
foreshadowed in MBU. It's completely consistent with what's in MBU.
Well, we can have a look at that and you can tell me, but I don't think there's anything in MBU that tells us that the carbon price traded between energy operators, aircraft operators, and others has to be the Green Book carbon value. There's nothing that says that, is there?
That is, Ricardo as an organisation spends a lot of time bringing the carbon price closer to the carbon value. That is what, in terms of policy
Okay,
advice,
that's a slightly different point. If you want to take me, and we can look at it now, to something in MBU that says that the carbon price is to be the same as the carbon value, then let's look at it.
It doesn't say exactly that. What
No.
it says is that MBU set out the planning assumption of 37.5 megatons of carbon, and it forecast that aviation would go above that, and to bring it back in line with that 37.5, there would either have to be a carbon trading scheme or a carbon tax which fixes the price.
Yes.
And what's happened is that 37 has come down
Yes.
significantly.
But what we have, we don't need to
37.5.
speculate on whether it's carbon capped or carbon traded. We know it's now going to be, well, it's a combination. It's a cap and trade, isn't it? A certain number of allowances will be given and parties can trade them.
One mechanism to reflect the carbon value
Yes.
is a carbon trade. Another mechanism to reflect that carbon value is potentially reforms to air passenger duty, which has been out to consultation. So I'm not speaking about something which government has, it's
Yes.
recently been out to consultation, and the results of that consultation are expected imminently, and probably at a similar time to the response to the Jet Zero consultation.
As far as we are currently concerned, the carbon price arises, doesn't it, from a reflection of the trading between the different parties within the system of their allowances?
Yes, but not as simple as that. Obviously, it's a new market, December 2020, and it's a smaller market than it used to be. And at the present time, aviation has a certain number of free allowances, depending on historical emissions. And so it's an incomplete and evolving market.
Okay.
So what I would suggest...
In a sense, we know it's only been established at the beginning of this year. We know it is coming into force, and so to that extent new. But I'm just trying to understand what the mechanisms are. There is a trading mechanism, and the price is a result of the trading between the parties.
Indeed.
Okay. And there are mechanisms for monitoring plans, aren't there? So aircraft operators have to monitor their use, their emissions, and then at the end of the period they have to surrender, don't they, the allowances sufficient to cover their monitored emissions. Yeah, Regulation 34. And if they don't surrender enough allowances, they get penalised in the following year. Yes?
Yes.
And there are enforcement provisions as well.
Yes.
And we know also this system currently operates from flights either within the UK or from the UK to the European Economic Area.
Yes.
We also know, again, we don't have it as a CD, but because the system is up and beginning to operate now, you can actually go onto the internet if you want, and you can look at the UK ETS aviation allocation table, and you can look at the list of,
Yes.
I was frankly amazed, huge numbers of airlines and what their allowances are for the next 5 years, I think.
Yes.
And all of those, again, relate to aircraft operators,
Indeed.
not airports.
From an airport's point of view, it's what would be called a Scope 3 emission. So if I can just unpack that for a second. From a carbon auditing point of view, and greenhouse gas emissions auditing has been in place for 20 years, and a Scope 1 emission is a fuel that's burned on site that the operator is directly responsible for, so gas use in a boiler. Scope 2 is electricity use that's used on site but produced somewhere else. And Scope 3, which is an aviation emission to an airport, is the aircraft emissions or the emissions produced from travel to and from site by customers.
And this is all set out in the CCCAP, isn't it?
It is set out in the CCC, in the Carbon Climate Change Action Plan, and carbon auditing is a process. However, Scope 3 emissions for an airport are something that is in their influence, but not in their control.
Sorry, I apologise, Dr. Hinnells, you're just straying. You know, this isn't a sort of tell me everything you know about ETS.
No, I'm not suggesting that. But what I'm
I
saying,
was asking you was whether the allowances relate to aircraft operators rather than airports, and the simple answer is yes, they relate to aircraft.
Yes,
operators.
they relate to aircraft operators.
Thank you. Now, in your rebuttal at paragraph 17, you make the point at your paragraph 17A that we don't know what the carbon cap will be. The UK emission trading scheme is set up, and we will not know until 2023-24 its design and what its carbon cap will be. The scheme at present is not designed to achieve net zero, but that, as we agreed before, setting the cap in order to achieve the 5-yearly carbon budgets, that's a matter for government, isn't it? It's
Indeed.
Government has a duty. It will set its cap on aircraft operator emissions consistent with its view of meeting carbon budgets.
That is one mechanism, yes. That is certainly one mechanism, but it would be simplistic to believe that it's the only mechanism or even the primary mechanism. And the point that I was making about Scope 3 emissions is that if a site has significant Scope 3 emissions, it is a risk to that site. It is an issue that if those emissions can't be controlled, then one option is to not consent the site. That's a perfectly legitimate policy response.
Well, so you say.
And indeed also...
Dr. Hinnells, let's, rather than you speculating on the planning system, which isn't even vaguely within your area of expertise, let's try and keep to climate change, which is what the inspectors can note is that the UK ETS is a mechanism which allows the government to control emissions from international aviation, and that the Secretary of State has a duty under Section 4 to ensure that emissions, including those from aviation, are within budgets.
And that is one way of doing it, and there are others, including air passenger duty and so on.
And there may be others, but the one thing that the inspectors can note is that the carbon budgets will not be breached, certainly in relation to aviation, because the Secretary of State has taken the legal mechanisms necessary to control those emissions. There's no doubt about that.
Well, since if you want to pursue that line of argument, one option is that the number of permits are reduced to the point and the price would fall so high that the airports could be built but could not be used. So that is taking your scenario to that end.
In the forecasting topic, we did look at carbon prices and variations around carbon prices. The sixth carbon budget was known about then. The UK ETS was known about then. We discussed all these things. I asked Mr. Foley about it. I asked other witnesses about it. I asked my witness about it. You may not have been here. But it was discussed, and the way the Monte Carlo modelling takes into account uncertainty around carbon prices. We did all of that. Now, here we're dealing with carbon, and what I want to understand is we can be sure, can't we, that the Secretary of State either has or can take the legal mechanisms or operate the legal mechanisms that there currently are to ensure that the fourth, fifth and sixth carbon budgets are met.
He could indeed, as you say, do that through emissions trading, but that is only one of the policy levers which he has at his disposal.
All right. There may be other mechanisms, but that at least is useful that we've
But my point is for the inspectors
to identify that.
My point is for the inspectors that one of the other policy levers at his disposal is to say, well, hang on a minute. Heathrow have suggested that we have an environmentally managed growth regime where we don't build until we can deliver the technology. Other airports have as well, including Luton.
That isn't what the Heathrow proposal was at all, was it?
It's included carbon. It's included a basket of measures, but it's included a basket
carbon of measures, as you will know for obvious reasons. I do know about those proposals. So
but
there are complete red
that's
herring.
One of several airports that are looking at an environmentally managed growth scenario.
I am aware of those.
And the Secretary of State could say, well, let's think about this. Let's link the expansion of capacity to the delivery of technology.
With greatest respect, I'm honestly not terribly interested in what the Secretary of State might think about, environmentally managed growth or other things. We're dealing with this proposal. I'm asking you about the particular lever of the ETS. We've agreed that the Secretary of State has the levers available to control carbon. You've made the point that he could do other things as well, but the inspectors can only consider what they know, what the policy context is, and what they do know is that the Secretary of State can ensure that the carbon budgets are met and has a legal duty to do so.
That's correct.
Okay.
He might also want to look at achieving those carbon reductions at a price, at the lowest possible price, that would be the economically rational thing to do. And to that end, that's why we were so interested in the fact that the CCC had said that capacity constraint has a zero cost, but demand constraint has a cost of something above £600 a tonne. They are very, very different, and it is a legitimate question. Why not start with the cheapest first?
All right.
Obviously, the cheapest first is efficiency, and then capacity constraint.
All right. Well, we have your view on that. We know there was a legal challenge, don't we, in the courts, that the emission cap in the UK ETS was too high to meet the Paris Agreement, and that was rejected by the courts, wasn't it?
It's an evolving policy.
All right. Now, in your rebuttal, paragraph 9, you make the point that it's 9E, no reliance can be placed on the UK ETS. And as we have just agreed, that's simply not right, is it? Reliance can be placed on the UK ETS.
I think if you read that in context, what you would find is that that the UK ETS will not deliver the 2050 targets on its own, and what I mean is that the ETS as formulated in 2020, given the points that are made above about the fact there are still free allocations, the fact that the carbon price in the UK ETS is still a quarter of the carbon value, it leaves a policy gap that prices and values should be more in alignment.
But we can agree, surely, that the government and governments over time, over the next nearly 30 years, will operate the UK ETS and other mechanisms consistent with the Section 1 and Section 4 duties. We don't need to speculate on it. We know they're legally obliged to.
They are obliged, indeed.
Yeah. We also know, you commented a little bit, I wasn't sure whether to ask you about the MPPF, but you've started to hazard views on it, so I'll take you to another bit. Can you look at the NPPF? So this is CD 5.8.1.
Sorry, CD 5.8.
5.8.1.
Yeah.
And tell me when you've got that, and I'll give you the page number, 54.
Yep.
And it's PDF page 54, and I want to take you to paragraph 188, which should be familiar to the inspectors, but what it says is, do you have it?
Yep.
The focus of planning policies and decisions should be on whether a proposed development is an acceptable use of land, rather than the control of processes or emissions where these are subject to separate pollution control regimes. Planning decisions should assume that these regimes will operate effectively. Inspectors have to assume, don't they, that the regimes that we've discussed, including the UK ETS, will operate effectively.
That's what it says. Yeah.
Well, and it's right, isn't it? That's what they've got to do.
Except that.
Well, there isn't an except.
Well,
that is the
no. That statement, that paragraph
policy
188 is
context within which they operate.
No, absolutely. Where we stand at the moment is that the consultation paper that we have in front of us has many weaknesses, and it would be, in my view, premature to consent when the chips may fall in a different way, and that assumes that the land use and planning policy is not part of the control mechanism, and therefore there is another part of the control mechanism. But land use and planning policy, capacity constraint has a role.
Gentlemen, it's getting a little bit discursive. It's much easier for us to follow the thread of the discussion if it's very much more question and answer. I'm very happy for you to say yes, no, but to be honest, I think some of the but is getting rather lengthy and we need an interruption to have a break.
So you could not have picked a better moment. How could I say otherwise?
Okay.
No, that's absolutely fine.
Right,
sir.
okay, thanks very much. Let's break then till 3:20. I don't think it's worth looking at. Are you going to answer? Yeah, I think so. Can take our seats and resume. Straight back over to you, Mr. Humphreys.
Thank you, sir. Dr. Hinnells, can we now just, again, touch on some of the legislation relating to Corsia?
So before we move off a national planning policy framework, if we may, just very, very briefly, you were right to point me to para 188 of MPPF. For the sake of balance, can I point you back to para 152?
152.
And I just want to make sure that the inquiry is aware of that paragraph. The planning system should support the transition to a low-carbon future in a changing climate. ... It should help to shape places in ways that contribute to, and I quote, radical reductions in greenhouse gas emissions. So as you point out, I'm not a planner, and I think paragraphs 188 and 152 are both relevant, and I will leave it to the planners to determine where the planning balance lies.
Thank you. Now, the next bit of the sort of legislative framework that I just want to touch on relates to Corsia. This is the carbon offsetting and reduction scheme for international aviation, and there, UK government has again already passed one piece of legislation, hasn't it, implementing that, the 2021 order. In fact, it's not a CD, but we don't need to look at it in detail. But the 2021 order, May 2021, I think it came into force, and that does two things. It notifies the UK's participation in Corsia as Article 7, but what it then does, it implements part of Corsia, and in particular the monitoring, reporting and verification requirements, doesn't it? So, so the UK is currently part of this pilot phase of Corsia. It's implemented in legislation the monitoring, reporting and verification requirements. I suppose important to note there's an equivalence, isn't there, for reporting and monitoring, the 1 ton of carbon for Corsia is equivalent to, is the same unit, isn't it, as under the UK ETS? They both work in single tons. Mm. Yeah? Could you say yes?
Sorry, I beg your pardon.
It's all right. Thank you. It just helps, particularly for those, our enormous audience out there listening in. Have both of them.
I apologise to the audience.
Exactly. And what government announced in its response to the Corsia consultation. So there was the Corsia consultation and then the response to the Corsia consultation, which is CD 9.43. I don't think we need to look it up unless you want to, is that the next statutory instrument will cover the second part of Corsia, which will implement the offsetting requirements, and that's planned for spring next year, isn't it? Yes?
Yeah.
Yes. And there are these three phases we know about: pilot first phase and then second phase. And Corsia obviously includes flights beyond the European Economic Area. And what government has been consulting on, is reported back to some extent, is the future relationship between the UK ETS and the Corsia scheme, and I think it's that relationship which will in effect be the subject matter of the second statutory instrument in spring next year. Is that your understanding too?
That would be my understanding, yes.
Okay. Now, obviously, you know, I know there have been criticisms of Corsia. You've made criticisms of Corsia, and government is clearly aware of those. It undertook consultation, but how government ultimately resolves that is a matter for government, isn't it? It's a matter of the national policy. But one option that the government has is in effect to apply the UK ETS to all flights, just as the EU ETS originally applied to all flights. Is that yes as well?
So that's yes.
Thank you.
Yes.
And we know for the EU ETS scheme that it temporarily suspended its operation for flights outside the EEA, but that suspension, the sunset clause, means that ends on 31st December 2023, I think, yes. And unless Corsia is working properly at that time, then the EU ETS will apply to all flights into and out of the EU.
Yes.
And the government could simply replicate that for the UK ETS.
Yes.
So we've touched on the sort of kind of legal framework. Within that, there's a policy framework. Again, we're still going through many of the points you've made. And, sorry, just one point on the Corsia ETS thing and the EEA. For Bristol, I think we can agree that it's about 88-90% of all flights are, in fact, within the EEA, aren't they?
From memory, that feels about right, yes.
Okay, sorry. Aviation policy, and I think you make sort of two, in effect, broad criticisms or challenges to policy. You on the one hand, you say, well, look, policy seems to be evolving quite quickly, and secondly, you point to what I characterize your concern as to be a tension between different aspects of policy. So let's just sort of explore some of that to see whether that's a fair characterization. You do draw attention to the aviation policy framework. The inspectors have been taken through that many times, and I'm reluctant, frankly, to take them through all of that again. But can we perhaps just agree on the aviation policy framework that there's nothing in that document that indicates it is government policy to constrain capacity at UK airports in order to achieve climate change objectives?
With Corsia, absolutely, I agree with that. Government is, as you rightly point out, keen that policy is international first, even if there are national measures that support it, given higher UK targets. And at no point is there a capacity constraint suggestion within an international framework.
Thank you. MBU, goodness, where to start? We have, Dr. Hinnell's, this sort of, to my mind, slightly surprising debate, but we do have a debate about the status and weight to be attached to policy. And again, I'm slightly reluctant to get overly bogged down in it, but your point, it was a point you made at Stansted, and it's a point you make again here, now in the context of the sixth carbon budget, that the MBU is out of date or needs review or is inconsistent with the sixth carbon budget.
The sixth carbon budget needs to update MBU. I think we saw from, and again, I'm not a lawyer, so I will defer, but my interpretation, my understanding of the Supreme Court judgment on Heathrow was that the ANPS is effectively, if Heathrow were to put in a DCO for Heathrow, the project would have to meet the carbon targets in place at the time and not the carbon targets at the time of the ANPS. I'm assuming, therefore, that the same is true with MBU, that the carbon targets that are associated with MBU are the carbon targets in place at the time.
Correct. Absolutely correct. And that's why in the environmental statement addendum, that's why we have set that as one of the tests. But we'll come back to that. Now, you say that is that, it's interesting, is that the reason why you are suggesting that MBU is out of date, that you think it does not mean, MBU does not mean that any project has to comply with the government's climate change obligations from time to time, i.e. as they are at the time of the decision? Is that the reason why you say MBU is out of date?
Well, the 37.5 budget does not apply beyond, as we discussed earlier, the fifth carbon budget period.
No. Right. Okay. And that's why Mr. Orson Island has looked at two tests, hasn't he? He looked at 37.5, which is, as you say, carbon budget 4 and 5, and then he also had a second test, which is, look, in any event, does this have a material impact on ability to meet government's climate change?
That's where he's used the gross emissions, not the net emissions.
Okay.
And
so,
that's where...
But gross emissions, not net emissions.
By that I mean the emissions from, so the 23 that CCC identified and the 21 that's in Jet Zero,
Yeah, but
they are an intermediate number, is what I'm saying.
But in his second test, he doesn't use the 23 or the 31 or the 37.5. In that context, what he says is, we won't exceed the carbon budgets because government has the UK ETS and whatever other measures it wants to make sure they are complied with, the thing we agreed with just before the adjournment.
But
that's the second test, isn't it?
But the carbon budget, in sixth carbon budget, hasn't been set for aviation or for any, well, it has been set for the economy as a whole, but not...
Correct.
So...
Correct.
It's not possible for BAL to say that they don't jeopardise that target because they don't know what the target is. And that's...
They do. It's set out in the carbon budget. Allowances will be traded between aviation and other sectors, but as we agree, the one thing we know is that the carbon budget will be met because government has legislation to ensure it will be met. And that's right, isn't it?
It is one scenario that would be correct. Yeah, you are correct, it is one scenario, one way of meeting it.
But what I mean, I don't want to go over that ground again. We've agreed the positions there, but what I'm interested to understand is that why you say MBU doesn't have full weight? Because you, in some way, regard MBU as meaning that we don't have to be consistent with climate change obligations as they emerge from time to time. Just as with the Airport's national policy statement, and it was always the government and Heathrow Airport Limited's case that Heathrow would have to comply with climate change obligations from time to time. There was never any dispute about that. Ditto with MBU.
But
is that your misunderstanding? Is that why?
It's not my misunderstanding. It's that number, that 37.5 budget, survives up until the end of the fifth carbon budget and not into the future. So that's one concern that I have. The other concern that I have actually is there is a significant difference in MBU between what the words say and what the numbers say, tables 1, 2 and 3 in MBU. The words describe a very permissive framework, make the best use of existing runways. And the numbers in terms of passenger numbers, aircraft movements and carbon actually describe quite a small additional increase. And I covered this in my proof. The numbers describe quite a small additional increase arising from MBU. And I do think that is an important test.
Okay.
That MBU, given the decisions recently, could be regarded as virtually full, even on its own terms.
Clearly, we know that your view on this, and it's interesting that you've expanded it a bit, but clearly we know your view on this is out of step with the view of government and others, and I'll try not to trawl through all the detail, but we can if you want to. We know that in February last year, Grant Shapps, MP, immediately following the Court of Appeal's decision on the AMPS, reaffirmed that MBU was still policy, refer to MBU. No indication there, in the light of the Court of Appeal's decision, that MBU was not current government policy or less weight was to be attached to it.
I think we need to discriminate between the three elements of the words, which nobody has any particular issue with, the numbers which we need to look at carefully given recent decisions, and the overall budget, the 37.5 in the light of climate change.
So about the budget. The planning assumption is something else. What I'm asking about is the policy. There were two policies, I think someone called them sister policies, that came out at the same time. The AMPS said the next runway in the southeast is to be the northwest runway at Heathrow. At the same time, a separate policy document came out, in some ways echoing earlier policy from the airport policy framework, but that said for other airports, the policy is that you should make best use of your existing runway. In other words, you don't develop new runways. I'm not interested in, for current purposes, in the planning assumption or not the planning assumption. What I'm interested in is just the policy, making best use of runways. We know, don't we, we'll perhaps come to it in a minute, that that is of course subject to the need to have regard to impact on climate change objectives. We've looked at that, but the policy, subject to obviously looking at that and other environmental impacts, noise, air quality and everything else, is that one should make best use of existing runways. Now, Grant Shapps restated that as policy, didn't he, in February last year. It's important the inspector should note that.
Sure.
The Stansted appeal decision, which again heard your concerns, not in relation to the sixth carbon budget, but all the other arguments, and again concluded that MBU remains current, up-to-date government policy, gave it full weight. The inspectors should take that into account, shouldn't they? Unless it's overturned by the High Court, but it hasn't been at the moment.
Sure. Unless, and and subject to the results of the consultation of Jet Zero, because the consultation, being a consultation, raised one way of meeting those carbon targets. And given the weaknesses that we've been through this morning, that is not the only way or the most sure way to meet the carbon targets.
Yes.
And therefore there could be a revision to that perspective.
Okay. In the July 2021 decarbonising transport policy, which is not obviously a consultation document but actual policy, there is no suggestion anywhere, is there, that MBU is out of date, no longer up to date?
The decarbonising, yes, the decarbonising transport plan was spectacularly light on commitments. Oh, beg your pardon, I just knocked the fan over. Was spectacularly light on
whatever
commitments.
you may think it is or is not spectacularly light on, one of the things it did not say was that MBU is no longer government policy.
No, it was silent on MBU.
Yes, and therefore we can look at other things like the Secretary of State. We know that Jet Zero, which whatever else it was consulting on, was not consulting on the airport policy framework or MBU, but very clearly had a statement in the footnote that MBU is the most up-to-date policy and is to be given full weight. Absolutely clear, isn't it? Clear as a bell.
It is, but it's in a policy statement. Sorry, it's in a consultation statement.
Yes,
and if
but
it
it's
was
not
a policy
consulting
statement,
on that.
Of course. Yeah.
Just to check what it actually says. Make sure the question is on a good basis.
No, that's perfectly proper. I do have it. It's on PDF page 51. 135, I think. Sorry, yes, CD 135. And PDF page 51. It's footnote 39.
yes.
I'll read it. I'll read it out. Forgive me. We've seen it so many times. I thought we were familiar, and if I've misquoted it, okay. Beyond the horizon, the future of UK aviation, making best use of existing runways, 2018, and Airport's national policy statement, new runway capacity and infrastructure at airports in the southeast of England, 2018, are the most up-to-date policy on planning for airport development. They continue to have full effect, for example, as a material consideration in planning decision-taking on applications for planning permission. The government is clear that expansion of any airport must meet its climate change obligations to be able to proceed, which is the point I was putting
Yes.
to you earlier. I mean, but I do suggest to you, and that, of course, postdates net zero, postdates carbon budget 6, postdates, Leeds, Bradford, Stansted, and in the knowledge of the Bristol application having been made, it's absolutely clear, isn't it?
Can I just decode it a little bit? It is very clear, but can I just decode it a little bit?
Well, you can certainly tell me what you
So,
think.
so what it says is that the two statements are the most up-to-date policy.
Yes.
In other words, there is no further update on those. They are the most up-to-date. That is not the same as being they are up-to-date.
And that's your point, is it?
That's part of my point. That's point
Yeah.
one.
What's your next point?
The second point is that it says they continue to have full effect. It does not say they will continue to have full effect. And I'm being very careful here. I've drafted consultation papers for government. So they continue to have full effect means to me they continue in the meantime to have full effect, not that they will continue to have full effect once the consultation's finished. So it's a statement for the period of the consultation. That's very careful.
Right. Okay.
And the last sentence, the government is clear that any expansion of it, that expansion of any airport must meet its climate change obligations to be able to proceed. That's an acknowledgement that, if you like, that's a nod in the direction of the Supreme Court that the targets need to be updated in line with policy.
So,
I read.
Based on that interpretation, you're telling the inspectors that they should not give full weight to MBU.
If that statement was in the policy statement in the
Did
transport,
ask whether it was in the policy statement?
no, it's
I'm asking, what are you advising the inspectors?
so
What weight should they attach to MBU?
so. Less weight given that it's in the consultation paper rather than the policy paper. It is a consultation paper
I'm
and
not asking about what weight you give to the consultation paper. I'm asking
No,
what
no,
weight
no,
you give
that's
to
not-
MBU.
I am saying that if that statement had appeared in the policy paper, it would carry the weight of policy.
What
it-
weight do you
We
attach
seem to be
to
making
MBU?
quite heavy weather on this. I mean, I took the point you were making in examination in chief. The question, I think, is pretty specific coming from Mr. Humphreys. I mean, from where we are now, what weight do you suggest we give MBU?
The words carry weight. The numbers, tables 1, 2 and 3, need careful examination because of the decisions that have been made under MBU. And the 37.5 carries no weight
Okay, so,
past the end of the fifth carbon budget.
all right. So the words carry weight, but the numbers in the table
1, 2 and 3.
1, 2 and 3 less weight, and the 37.5 we see in the context that obviously it doesn't apply in the sixth carbon budget.
And forward to 2050.
Okay. And for the words, so put aside the 37.5 and the tables 1, 2 and 3, for the words, you say they carry weight. Do they carry, if I say full weight or significant weight, I mean, you know, I don't want there to be any misunderstanding between us.
There is nothing wrong with a permissive environment for commercial organisations wanting to use their runways. The issue is carbon.
Okay.
And
So does that mean that you would be advising the inspectors that full weight applies to the words?
where they don't talk about carbon. So the permissive framework is a reasonable position.
Okay. And all right, I think I understand your position, which is important. Of course, we've had an even more recent statement from the department, don't we, about MBU. Can we look at the DFT letter that we had on the 13th of August? That's INQ 042. So INQ 042. And in that, I think you need to turn to PDF page 23. And there was a question, there were lots and lots of questions about the Jet Zero consultation, and question 24.3 was one of those, but the second response there regarding query 24.3b, do you have that?
Yes.
The government has set out its support for airports making best use of their existing runways in its existing policy statement, beyond the horizon, making best use. MBU remains the government's current policy and continues to have full effect in planning decisions. As stated in footnote 39, the Jet Zero consultation, the MBU continues to have full effect in relation to planning decision taking. So, again, it's pretty clear, isn't it, what certainly government's view is of the status of MPU.
Again, words, numbers, and carbon target. I don't think I would change my statement.
Noted. So, in your own proof of evidence and coming to your own conclusions, you are clear, I think, that insofar as later in the inquiry we're looking at planning balance and things, insofar as one's looking at the words of making best use and that airports should make best use of their runways, full weight can be given to that in the planning balance, but your position is that less weight would be given to the three tables you've identified and the 37.5 megatons beyond carbon budget 5.
Exactly.
Thank you. Well, at least we've now confined, you know, where agreement and so on is, and that's helpful.
I would encourage you to look at tables 1, 2, and 3 because the additional capacity envisaged under MBU is really quite small in the scheme of things.
Now, as far as the contents of MBU is concerned, and I'll try and keep off the three tables and the 37.5, can we look now just at MBU CD 6.4? CD 6.4. And let's go to PDF 5 and then 6. And on those pages, so PDF 5 and then PDF 6, we have the text on the role of the local planning system and the role of national planning policy. In other words, the words, I'm putting to one side the tables because I know
Sure.
you have reservations about those, but that distinction between the things that are appropriately matters for local policy and those that are covered by government policy, that I think you do accept is, as we described just now, the words are government policy.
Yes, yes. And it's quite right that carbon should be an issue of national importance.
Yes.
But that doesn't rule it out being an issue of local importance as well. And had it done so, I think it would have conflicted with the National Planning Policy Framework. What is now paragraph 152, it used to be 148 in the previous version.
And insofar as carbon or CO2 emissions are relevant, and we know from the EIA regulations that one has to quantify emissions, and that has been done. And clearly that quantification should be taken into account. Isn't it also right that the inspectors should take into account, this is reflecting the approach in MBU, the national legislative and policy measures to control aviation's emissions?
Yes.
Thank goodness. I thought we were ad idem on that, and clearly we are. As far, just moving on slightly, as far as the airport's national policy statement itself is concerned, again, I don't think we need to look at that, but CD 6.9, we know in that, paragraph 5.82, that the approach is increase in carbon emissions alone is not a reason to refuse unless the increase is so significant as to have a material impact on the ability of the government to meet its carbon reduction targets and budgets. And that, I think, in effect reflects what you say is the policy test, your paragraph 71 and the answers you've given earlier.
Yes. Other than to note that, as I say, it should be the net target, not the gross target, and it should be 2050 date rather than
I was taking targets to be section 1, that's the 2050 target, and budgets to be the 5-yearly budgets.
Yes.
Which I think is what is being referred to.
Yes.
What I think is being referred to there. Can I just move on then slightly? In the government's response to Corsia, CD 9.43, we might just look this one up. The government, perhaps turn to PDF page 6. The government here, and it was in the context of Corsia, but it just happens to be one of the most recent statements about non-CO2 and the treatment of non-CO2. The government, under government response, the second of the paragraphs there, by all means read the first just to see what it says, but the second of the paragraphs there makes the point that the UK continues to negotiate in ICAO for increased environmental ambition and supports the continued work on aviation's non-CO2 climate change impacts, their trade-offs with CO2 and possible mitigation measures, and the government keeps non-CO2 emissions under review and reassesses the UK policy position as more evidence becomes available. As far as non-CO2, so we're now talking about we're not talking about the Kyoto greenhouse gases, we're talking about, well, of the Kyoto greenhouse gases, methane and NOx are very tiny, aren't they? 1%, I think, of emissions for aviation.
Yes.
Yeah. So I'm really focusing on the non-Kyoto gas effects, contrails, cirrus clouds, the other things that Manchester Metropolitan and Dave Lees and others look at. There are a number of, I suppose, just sort of factual points, I guess, to make about one of those. One of them, and one of the difficulties, that for some of these effects, contrails would be an example, although they have a warming effect, that warming effect lasts for just a few hours.
Mm-hmm. Yes.
And even when the contrails lead to cirrus cloud formation, that would typically be just a few days, and then that effect has dissipated and goes
Yes.
away again. Some of the non-CO2 effects have a climate warming effect, but indeed some have the opposite. Some actually have a cooling effect,
Yes.
don't they?
Yes.
None of them currently, as we've agreed, are within the UN framework or Kyoto or Paris Agreement contributions.
They're not within the nationally declared contributions, correct?
No.
But Paris, because it's on a temperature basis, must include any and all warming.
The problem, which is faced by all interested in this area, is although it's recognized that there is some effect, it's very difficult. It's difficult to quantify these things, and B, it's very difficult to measure them against anything, because there's no budgets, there's no anything to measure such effects against.
They can be converted to carbon equivalents, and,
Yes.
and indeed that's what David Lee has shown in
Yes.
his work.
And for some of these effects as well, they're obviously the sort of things we're talking about, very localized. A contrail will have
Yes.
effect in a particular area, but it's not a global effect. It's an effect at that immediate place where
In
the
some
aircraft
ways,
is.
the parallel is better that we look at it as if it was an air quality issue rather than a
Now-
climate issue. It's a local issue.
In that context, there is no policy requirement, no UK policy requirement, certainly that I've been able to find, that indicates that one should seek to quantify these effects in development control decisions.
That's
And point me to something if you want to, but otherwise let's not just...
I think best practice now would be to include them in
No,
quantification.
not best practice. Do you want
Okay.
to point to any policy that says one should quantify them?
Off the top of my head and at the end of my fingertips, I don't have that.
No.
But I would agree with you that there's no policy requirement
No.
to address non-carbon warming impacts.
But what the Environmental Statement Addendum, CD 2.20.1, did in its section on non-CO2 was to acknowledge such effects, acknowledge that there is that these things may have an effect, and that international work is ongoing to try and understand this, and that it's anticipated that at some point an international consensus and policy will emerge, and that at the moment that's the proper response, isn't it?
It is the proper response. What I would say is that, as I said earlier, it's been under discussion at IPCC level since 1999. So there's 22 years. We are now 29 years off the Paris targets, the midpoint of the century. The sooner we deal with it, the better, because dealing with it later carries warming impacts, and those warming impacts are material. But from an industry point of view, this is not a policy point, and this is a personal view, but in my view, the industry would be well advised to deal with it earliest rather than later, simply because we're now entering a period when there is significant investment in mitigation, carbon mitigation. And if in doing that you can kind of hit two moles on the head and deal with non-carbon warming impacts at the same time, perfect. If by hitting one mole on the head, another mole pops up somewhere else, that risks leading to stranded investment or a misallocation, I should say, a misallocation of investment in what is going to be an expensive process. So from the industry's point of view, it would be in the industry's interest to have a resolution soonest in the interest of dealing with this as a warming issue, because we're getting closer to the, having started this a long time ago, we're getting closer to the point we actually have to have done something about it.
I never thought I'd have the chance to say the word whack-a-mole in a planning inquiry. Thank you very much, Dr. Hinnells. Passing on. In fact,
but I agree with you, there is no policy
mitigation work, but in fact, I think you will be able to confirm this, in fact, a lot of work is being undertaken on exactly these types of mitigation. So aircraft wing design that would try to reduce contrails, and also I think research is also looking at whether it's possible to identify, it's not all areas, identify areas through which aircraft would fly that have atmospheric conditions that might give rise to contrails, so
Indeed.
that those can be avoided.
Indeed.
So this is an active area of
Absolutely.
research on mitigation, I think.
It is, and good luck and all speed.
Yes.
The issue that will be a challenge is if in flying at a different altitude to avoid contrail formation, you then incur more CO2.
And that's a balance that's
And that's a balance, but it is important that if the industry does the right thing, it is recognised to have done the right thing, but it should also be encouraged to do the right thing.
Now, as far as, still on policy, as far as decarbonising transport is concerned, that document, so CD 9.134,
Sorry, is this a transport decarbonisation plan?
yes, sorry, did I?
Can you give that reference again?
Yes, CD 9.134.
Thank you.
This obviously is a recent statement of government policy. This particular document is not a consultation document, is it?
Agreed.
And I think in your proof of evidence, you said it was premature to determine the appeal before this was published, but I think you'll, it was your paragraph 95, I think you'll now say, well, I didn't know there was going to be a Jet Zero consultation and we're premature because of that. So, but this was the document that you were, I think, telling us was important, and it would be premature to determine before.
So that was in the proof?
In the proof.
Yes, this was published after the proof and necessitated the supplementary. This, together with Jet Zero and the further information on Jet Zero and the consultation on sustainable aviation fuels together. The sustainable aviation fuel mandate.
Now, what we do know from this document, and again, I take it from your comments earlier, are critical of this as well, but PDF page 4, we can see the clear direction of travel of government in the forward to the policy. So in the 5th paragraph on that page, so just over halfway down, that it says this is not about stopping people doing things, it's about doing the same things differently. We will still fly on holiday, but in more efficient aircraft using sustainable fuel. And obviously, debate about the detail of that, and we'll touch on that later. But there's nothing in here, is there, that indicates that it's government policy that it should be restraining capacity at airports. This is about letting people want what they want to do, but doing things differently.
That is a paragraph that I would disagree with.
When you say you disagree, do you mean you disagree with the policy?
Yes, and I accept that's the government's policy, but I would remind Mr. Shapps about the very dully named Standing Advisory Committee on Trunk Road Assessment in the early 1990s, which basically said you build more roads, you induce more traffic. And the same is true of airports. You build more airports, you induce more airports. And if it was saying it's about doing the same things differently, in other words, we have capacity for roads, we have capacity for flying. Let's stick with that. That's one thing. What I think is at issue is the assumption that we can grow our flying by 60% compared to whatever baseline year government used, and it was a bit confused about whether it's 2016 or 2018.
We may be slightly straying on beyond my question. We can see what government policy is. Your position is you do not accept that policy. You disagree.
My policy is that we've known for a very long time that you build more roads, you induce more traffic, you build more airports, and you induce more flying.
Okay. So it's a straight challenge to government policy.
Well, yes, it is.
Okay.
About straight
challenge
challenge going
more
forward.
About it. It's a straight challenge to government policy.
Do we need to travel less than we do now is a different question. But I take your point, restrain.
And then PDF page 8.
But before we do stray from that sentence, that paragraph that we were discussing, if we cannot deliver the technology, if the Secretary of State finds that sustainable aviation fuel and so on does not deliver the savings, then, and we went through all of the technical challenges that they have with implementing Jet Zero this morning, then either capacity constraint, which is cheaper, or demand constraint is a tool that the government has recognised. Certainly demand constraints is a tool that it may have to use.
Okay, the simple question is there's no suggestion yet there, and no suggestion anywhere else in this document, is there, that the government is considering capacity constraint?
There's no suggestion in that paragraph.
Or anywhere else in this document?
Not in this document, but as I say, this document is light because the detail was in Jet Zero and it was out to consultation.
All right. PDF page 8. Again, this is referring to aviation in particular, the sixth carbon budget, and it refers to the Jet Zero consultation.
Sorry, which paragraph, sir?
I'm so sorry. It's the third paragraph on that page.
Starting air travel may represent.
That's it.
Yeah.
If you want to look through it, it's the same theme, isn't it? For example, international connectivity is a vital part of global Britain. Everyone should continue to have access to affordable flights, allowing them to go on holiday, visit family, do business, and so on. I'm not going to just read it all out, but again, there's no indication at all that the direction of government policy here is about constraining people at particular airports from doing the things that they want to do. The emphasis is very much on doing things differently and decarbonising
Indeed.
flight.
There is a big caveat on that first sentence. Air travel may represent only 7% of UK greenhouse gas emissions, because as we know, the rest of the economy is decarbonising rapidly, whereas aviation is increasing. And so it's currently 7%, yes. And should we be able to take into account the non-carbon effects, it's much higher than 7% of UK warming. And that's why it is rightly the focus of a lot more attention.
Okay. And again, it's also pretty clear from this document, isn't it, that the government envisages that its policies will continue to develop over time. Page 44, PDF page 44.
Yes.
Right at the bottom, over time we will continue to develop and refine a range of policies and proposals set out in this plan to ensure that the transport sector fulfills its contribution.
Yes. But in the absence of those fully formed plans, and we come back to our point about prematurity,
now, Jet Zero consultation itself, so CD 9135, you were asked about this, and again, I just want to understand your view on the weight to be attached to it. Could you just have the MPPF open again? I just wanted to make sure I've understood. So that's CD 5.8.1. And you were taken to paragraph 48 and 49. Just to assist the inspectors, when you were taken to paragraph 48, and in particular paragraph 48A, so this is on PDF page 14, under A, which is the stage of preparation of the emerging plan, you said, if my note is to be believed, that, well, this was at an early stage of preparation, it was very early emerging plan. Do you recall that? And that's why, one of the reasons why you would give it very little weight.
As a consultation paper, obviously it closes tomorrow.
Yeah.
But as
I know what day it closes.
As a plan to get from here to 2050, there's a lot of work to do.
Okay. Under 48A, you characterized it as at an early stage. Is that right when you were talking about weight?
It's
not a difficult question. I'm just asking you to confirm what you said. It's not a trick.
there's a lot of work to do on it.
So,
certainly.
Is it at an early stage?
Well, the government wanted to bring it out before COP26.
Do you have a view on whether it's early?
Do I have a view? I think they need a lot of help.
Okay. Well, if you don't, when you were at paragraph 49...
In the government's view...
No, not in the government's view. I'm asking you about your view. It's a really simple question. I mean, you know, we'll be here for hours.
Yeah.
Just tell me what you think.
It needs a lot of work. It could happen very quickly. It's...
All right. When you got to paragraph 49, which was prematurity, and 49B, the emerging plan is at an advanced stage, on that, you told us, yes, it was at an advanced stage.
Well, the
and-
consultation's nearly complete.
Yes, but don't you see there is a somewhat a contradiction between
Yes, there is.
the two? On the one hand, you're telling us it's at an early stage for paragraph 48, and for
Well,
paragraph
actually,
49,
to tell the truth, it doesn't matter what I think. It matters what the government thinks, and the government thinks the consultation closes tomorrow.
Okay. All right. So, insofar as the council has a point on weight under paragraph 48 or prematurity under 49, you as a witness express no view. Given you a chance.
It is both very late in the day, and there's a consultation paper, and it is far from perfect. And if you like, it is very controversial, and there are unresolved objections.
Can we, as I said right at the outset, you spent a huge amount of your evidence in chief and a large part of your supplementary just attacking the Jet 2 consultation. I mean, it is just a consultation. Parties will make their views known, and the government will decide what the government decides, won't it?
Indeed.
What are you expecting the inspectors to do? They're not running the consultation. They're not
No, sure.
deciding.
Sure.
What on earth do you want them to do? You've given them hours this morning of evidence on things, an entire supplementary attacking the entire basis of the consultation and indeed suggesting that it's illegal or unlawful. What on earth do you want the inspectors to do?
At the present time, I don't believe it's safe to consent the scheme.
No, about the Jet Zero consultation. What on earth?
There's nothing that they can do. It's for government to do.
Right, it's for government to do. So
Yes.
they have to act, don't they, as we've been discussing before, within the legal framework and the existing policy framework that we've been discussing.
Yes. Existing and emerging.
And, well, emerging, I mean, they can note that there is an emerging position, but I ask you what weight should be attached to Jet Zero, and I'm not entirely sure what your answer is.
Well, my answer was clear this morning. Very little weight, because first it's a consultation,
Yes.
and second it has flaws, which we went through this morning.
Yes, but you will make those flaws, or the council will make those flaws, or other will draw attention to those flaws to government. Government's not here to defend itself, and it will no doubt consider whether those are flaws, and if they are, it will deal with them, and if they're not, it will reject that. Won't it?
Yes.
Mr. Humphreys, I think, as far as I'm concerned, I think we're there now on the weight to Jet 2.
Yes.
So perhaps move on.
Can we just, though, turn then to, not to Jet 2, but some of the other things around Jet 2. So we know that there are a number of other bodies that are either referred to in Jet 2 or have made submissions, and just want to identify in broad terms what their positions are. So the Jet, so I keep saying Jet 2, and I
think
know
I
I
started
do.
it, actually.
Jet Zero.
Yeah, Dr. Hinnell's, you know, it's week 6 of a very long inquiry. I apologise. If I say Jet 2, I mean Jet 0, and I apologise to everyone. The Jet 0 Council, we can see the bodies involved in that particular organisation in CD 9.56. There's huge numbers of leaders within the industry, So
Indeed.
airlines, they're all listed, airlines, academics, airports, manufacturers associations, Airbus, Rolls-Royce, Zero Avia, and others. That body is not saying, is it, that the objectives of decarbonising aviation are not achievable. Clearly those organisations, in many cases individually and also collectively, are very supportive of the initiatives.
Absolutely.
And another organisation, Sustainable Aviation, which is obviously an industry-related body, we can see who they are. I think CD 9.132 was one of their publications.
Sure.
UK aviation industry strengthens commitment to achieving net zero and launches first interim decarbonisation targets. Again, that body is not pushing back and saying, no, don't impose this, this can't be done, we can't possibly achieve this,
No,
we'll
absolutely.
never have growth.
Absolutely.
They're welcoming it.
But I do think there's a risk in that group of what you might call, if you like, an optimism bias of seeing technology as the solution.
Okay.
Whereas, and I think it would be helpful if there was a more rounded membership of that group. It is an industry group, and I feel it's probably had a very strong influence on the flavour of the consultation.
But let's look then, you know...
For example, there's no local authority on there. There's no Whittlesford or North Somerset Council. Or,
no, that's because it's obviously an aviation body. But my point is, they are not pushing back and say, government, steady, we can't do this. What they're saying is, yes, absolutely, we are committed to this as well. And the inspector should note that. It's important.
Well, what's interesting actually is in more than one case.
Should the inspectors note that?
Yes.
Yeah.
And what's interesting is in more than one case, Sustainable Aviation as an industry group feels that it could go further and faster than Jet Zero in terms of reducing emissions. And I find that interesting.
Okay. Can I take you next to the Ricardo report that you have referred to? So this is CD 9.133. 9.133. 133.
Yes.
And I just want to look at the summary, PDF page 68, to see what your own company has been advising. And indeed, I think this is one of the footnotes, isn't it, to decarbonising transport. You are one of the inputs to decarbonising transport. So PDF page 68, the summary. So the first summary point is sustainable aviation
Sorry
fuel.
to interrupt.
I'm so sorry.
Let me just check. We're on CD.
I've got CD 9.133. 133.
The Ricardo report.
Ricardo report.
Right.
And PDF 68, yeah.
Bear with me just a second.
That's all right, sir.
Got it. No, I know where we are. Sorry. Thank you.
You know, here's your own firm's view on these things. Sustainable aviation fuel is a major route to decarbonisation for the UK aviation industry, given that the alternatives will be unable to service medium long-haul flights, e.g. electrification, or at least 10 to 20 years away from realisation, hydrogen. So,
Absolutely.
You do, as a firm anyway, see SAFs as being
Absolutely.
an early win, if I can put it like that, for decarbonisation.
It's not an early win, it's a big win.
All right, a big win.
Yes,
for
but it is not,
decarbonisation.
it's by no means an early win because we are still doing first-of-a-kind demonstrations.
And the medium to long haul flights, you say electrification, the alternatives in terms of medium to long haul flights, but we know that for this airport, Bristol Airport, it's nearly all short haul flights. So in fact, electrification, on your own analysis in this document, is an option, or will be
Great.
an option for...
It's not in the impact assessment now.
No. And for hydrogen, at least 10 to 20 years away, yes, but within the horizon to 2050...
Great, but it's not in the planning application.
No, we're not applying for aircraft, we're applying for an airport.
No, absolutely no, but the point is, I mean, to take into account hydrogen at an airport, for example, if you're filling a plane with hydrogen, the safety margins around aircraft are larger than they are for conventional fuel aircraft. So design the stands for hydrogen, or if you're going to have electric planes, think about a new grid connection. I'm sorry, I'm not here to offer advice on the design of the airport. I'm here to look at the planning application as it stands now.
That's why airports have permitted development rights that allow them to adapt their stands for those sorts of things. That's why government has given them those powers. I'm not going to cross-examine you on the planning.
No, sure, no.
Let's just go back and look at the second of these. Globally, there is an emerging sustainable aviation fuel market. The UK currently has no production of SAF at commercial scale. Government input is needed to level up the UK's position and bridge the gap between new technologies and commercially demonstrated plants. Now, we know on that that the government has been making announcements around those sorts of things and is pretty determined to put UK right at the heart of this
Yes, indeed.
emerging industry. Three,
Accept that, and this is a material issue, the budget, so the Sustainable Aviation Industry Organisation asked for 500 million for sustainable aviation fuels and said they could match it with another 500 million from commercial sources, and they got 15. We all know that things are tight at the moment, and as I said before, Ricardo runs that Green Fuel, Green Skies support programme, so I'm not seeing anything that I would disagree with here.
yeah, your third point, there is a large opportunity for government action to leverage substantial UK low-carbon growth and green jobs in the sector, all supporting the Jet Zero agenda post-COVID-19 economic recovery. And indeed, one of the places where your report was cited in decarbonising transport was in relation to the enormous opportunity for job creation, wasn't it?
Yes, well, I'm all I can say is yes. There's nothing to disagree with.
There are a range of technologies at different maturities that could produce SAF, and a large, incredible pool of bidders that could enter a competition to build plants in the UK. Broadly, these can be grouped into pilot and demonstration scale projects. The first of a kind, FOAK, first of a kind, commercial products. I mean, Ricardo isn't telling government or anyone else that reads its reports that this can't happen. Ricardo is absolutely behind all of this stuff, isn't it, as a company?
Yes. Well, yes, we have a lot of expertise in that area, but it's still at a very early stage. It's very important. It has a huge opportunity, but it's still at a very early stage.
In August, another document, in August 2021, the UK announced the UK hydrogen strategy. We have that, I think, as INQ 034. I don't need to look at it, but again, that's says a lot about aviation. It's very positive, isn't it, about aviation, hydrogen in aviation?
Absolutely. But from very small beginnings.
Of course. In the Jet Zero, yeah, I got it right, didn't I? In the Jet Zero consultation, again, we can note that amongst the various measures, there were the 5 measures, if you remember, one of which was influencing consumers, none of those measures involve capping capacity.
Yep.
Insofar as there is any indication that there may be an effect on growth, it's an indirect effect, isn't it, by...
As the government sees it at the moment, yes, but the Airports Commission explored those options before we went to, whilst we were still looking at an 80% cut in CO2. The Climate Change Committee explored those options in the 6th carbon budget. I do not understand why they were not at least part of the analysis for Jet Zero, even if it wasn't the preferred option.
Yes.
I don't understand why it was not part of the analysis, and in that regard, it's
speculate on why you think they've got it wrong, if you like, but the inspectors have to deal with what's before them, and as we agree, there's nothing in the document. I accept it's a consultation document, but nothing in the document or decarbonising transport to think that the government has capping capacity at airports as part of the arsenal of things it wants to do. No indication at all, is there, in any of the documents? If there is, take me to it.
not in Jet Zero.
Or anywhere else.
In the evidence that supported Jet Zero, I think there was a paragraph that referred to this that was less certain than footnote 39.
Dr. Hills, if government thought that capping capacity at individual airports was a mechanism, wouldn't need to hint at it. It would say, look, capping capacity is a mechanism. As Mr. Young put to you earlier, the government could have recovered jurisdiction here if that was the strategy and just said, look, I'm very sorry, but the policy is no expansion of airports. Refuse, appeal. Just not done that. All you're doing is speculating on what government might do. There's no basis in policy or even emerging policy.
No, I'm not speculating on what government might do. What I'm saying is that the plan that government has, the scenarios that government's put forward, are riddled with uncertainties such that another policy option is highly likely to be needed in order to meet the binding targets that we have and the duty of the Secretary of State to meet those targets. And in that context, a decision to consent, in my view, would be premature.
So I'm conscious of time, and you know, I do confess I haven't made quite as much progress as I'd.
What would you estimate?
There were one or two follow-up sort of areas I just wanted to touch on as the consequences of these things, and then I wanted to have a section where, you know, we actually looked at the ES and ESA assessment. You know, what have we actually assessed, and then how does it fit within that picture? Now that final section is not all that long, but it certainly wouldn't be over by 5 o'clock, and I do apologise.
Mr. Taylor, at the moment, much re-examination?
So I think in the region of about half an hour.
Yeah, I think we're as one on this. I think it would be very helpful to finish the cross-examination tonight and then come back for re-examination tomorrow morning when we're fresh. So we'll press on. Do you need a break? Does anybody need a comfortable break at this stage?
Fine.
I'm absolutely fine.
Okay.
It's been very helpful, by the way, to have the windows open, so that's, thank you.
Okay. Right, let's press on then. Thank you.
And so I'll certainly, I have been trying throughout, I've missed a number of areas that I was going to cover, and I will continue to try and move as fast as I can. Dr. Hinnells, one of the points that you then make in your evidence, and this really is in the context of MBU and cumulative assessment, is that the point you touched on just now, it would be premature of the inspectors to come to a decision because some sort of overall strategy needs to be developed at a national level in order to decide where growth should take place. I'm paraphrasing your point, but in broad terms, that's what it is, isn't it?
Indeed.
And you recognize, obviously, that can't be done, that we cannot do that. We can draw attention to what other applications there are. Indeed, we have done that in terms of carbon, and but it's not for the applicant to make some national assessment, and as you've rightly pointed out, it's not for these inspectors to make that, and therefore that's not going to happen. So is it, in effect, your point that there is at the moment some sort of national moratorium?
There is an interregnum, not a moratorium, if I can put it like that. I think in the interest of time, I summarised this in the conclusions to my proof and reiterated them in the conclusions to my supplementary. I don't think I've got anything to add to what's in the proof, particularly supplemented by the supplementary.
We can agree, though, can't we, that there is, firstly, no statement from government that there is either an interregnum or, as I've called it, a moratorium. In other words, you shall not grant permission.
There is no moratorium, that's clear.
There have, during this period, since net zero was announced, been a number of decisions taken granting permission for growth of airports.
Since Jet Zero was announced?
No, sorry, if I didn't make it clear, since net zero was announced.
Right. Yes, including Stansted. Very shortly after the net zero, the inclusion of IAS, International Aviation Shipping, within the UK carbon target. But as discussed, that is at appeal at the present time.
And as we've already discussed, in none of these cases has the inspector recovered jurisdiction.
Sorry, as the Secretary of State?
In none of these cases has the Secretary of State recovered jurisdiction.
I accept that.
For the inspectors to refuse permission on a prematurity argument would need pretty clear statement, would it not, that a decision to grant is contrary to some policy or strategy or overall assessment, and that has simply not been provided by government. Government could make that statement, but just has not done so.
Sorry, you're saying that a decision that the government could decide that is premature?
Yes. You are making the case that this is premature because government should come to some overall decision on the location of expansion in airport capacity. We've agreed that there have been decisions. We've agreed that there is no there is no policy moratorium or interregnum. And
sorry, a moratorium and an interregnum are very different things. A moratorium says thou shan't.
Yes, well, it would be a moratorium in the interim, wouldn't it? That's in effect what you're saying. You're saying you should not grant planning permission now until something else happens.
That's for government to say.
Exactly.
But,
that is for government to say.
But that would be a moratorium, and there isn't a moratorium. We're going around in circles, we agree that.
All right.
What I'm saying is that we do have a policy interregnum where Jet Zero as a consultation simply cannot deliver, for reasons we discussed this morning, the objectives it set for itself.
Well, so you say.
So I showed.
No, so you say. Government is not here to give its view on that. You've just, in effect, given a representation on a consultation document to two inspectors. Let's try and move on, Dr. Hinnells. The assessment in the ESA, the methodology for calculating carbon emissions, the methodology and the number, as I understand it, is agreed. There's no dispute about what the calculated emissions are.
I don't have any dispute with that. We were able to replicate the calculations that showed the level of emissions from the proposed development.
It's accepted that the significance of those emissions should be judged by whether they have a material effect on the ability of the government to meet its carbon targets and budgets. So on significance, we agree that that is a test.
Yes.
You don't agree in relation to the period of carbon budget 4 and 5, where the planning assumption was used, that it is appropriate to test significance by looking at the size of the emissions against the planning assumption.
That would be reasonable for planning for carbon budgets 4 and 5.
That
because
would be for 4 and 5.
That's what's in place for periods 4 and 5, but not for the period from 2033 onwards, which is and the ESA did not discriminate between carbon budgets 4 and 5 and 6 onwards.
Okay. The assessment, I think the things that we're, not just the numbers, but the things we assess, so with and without the development, and then a range of different years, 2024, 2030, 2040, 2050 in the ES addendum. No argument that we've looked at the appropriate years. That's all agreed.
That's fine.
I don't think any argument that we've looked at the right sources, so we've looked at aviation, surface access, airport buildings and operations and construction, included embedded carbon. That's perfectly proper.
That's fine.
We also looked at a range of emissions, an upper central and a lower scenario in each case. That's agreed as being appropriate, I think.
Yes, I think that's appropriate.
We looked at the emissions not only against the 37.5, but we also looked as a sensitivity at the CCC's other figures that it used for various purposes, the 31 megatons and the 23 megatons, and that's perfectly proper to do that.
As I said earlier on, I don't think that's relevant. I think the relevant number should be the net emissions after offsets and removals, preferably removals, not the gross remaining emissions.
As far as the, so we have included in our evidence the two tests, looking at the 37.5, which you agree is appropriate for the fourth and fifth carbon budgets, and then we've looked at the tests which you identify, material effect on carbon reduction targets. I think on that, on the first of those tests, looking against the planning assumption, we say that the emissions from the proposed development are very small, 0.22 of a percent in 2030, reducing to 0.17 or 0.2% in 2050. I think your point on those is it doesn't matter what the percentage, as long as it's positive.
Well, my point is that 37.5 is retired by the end of the fifth carbon budget. To compare it to 37.5 after that is not appropriate.
Yes, but in 2030, which is the year that we've been looking at, where we get to 12 mppa, at that point it's 0.22% of the planning assumption. Do we agree, I mean, maybe we do, maybe we don't, but do we agree that at that point, in that year, against the planning assumption, that that is not a significant effect? That's a very, very tiny percentage.
Well, the policy target is not for 2030, it's for...
I know, but for that year, which would still be in the fifth carbon budget.
Well, that's not the point at issue. The point at issue is the sixth carbon budget period.
I know.
And 2050.
We'll ask you about the sixth carbon budget,
right.
But for that year, which is the assessment year, or one of the assessment years, do we agree that that is such a small percentage as to not be a significant adverse effect?
Well, I'm not going to argue about that. As I say, I think that the important period is the sixth carbon budget and 2050.
Well, sorry to be persistent, but I'm not going to argue about that. Do you mean you're not suggesting that that is a significant effect because...
I don't want anywhere to be quoted saying that I don't think there's a significant effect here, because there is, but you're just looking at the wrong year.
Okay. In terms of the second assessment basis, which, as you said, particularly relates to the sixth carbon budget period, although so the same mechanisms are available before that, we have agreed, haven't we, that a combination of the UK ETS and Corsia and other measures which the government would be perfectly entitled to take means that the sixth carbon budget will not be breached. There's a legal duty and the mechanisms are available to ensure that.
It would be a breach of the law if the budget did not meet that. At the present time, I don't think the government has demonstrated the means to deliver that budget for reasons we went through at length this morning.
Yes. You have been looking, though, at things in sustainable, in the Jet Zero consultation. I'm not asking you about those as means. Those are just pathways by which industry will change over time to deliver growth. What I'm asking you about is the legal mechanisms that ensure that the budgets and ultimately the target are not breached. Put it to you again, and I think it's common ground. We've, I think, agreed it twice, haven't we? That in the context of the sixth carbon budget, and indeed beyond, the government has the legal mechanisms to ensure that there is no material effect on meeting the budgets and the target.
I don't know how many different ways to put this.
Well, you could just say, yes, that's what we've agreed twice.
The government has those obligations, but
And the levers and the mechanisms, the legal
levers,
mechanisms.
but not all of those levers are in place, and the measures that are in the Jet Zero consultation
I'm
will
not
not deliver those
interested
targets.
in the Jet Zero consultation. I'm interested in the legal levers that government has to ensure that the carbon budgets, through the ETS, the handing out of allowances,
There will come a
handing
time.
out of allowances, that means that the carbon budgets will not be breached.
You're looking at this, forgive me, you're looking at this from a very legalistic perspective, from an operational perspective. At some point, if you only used carbon pricing or carbon trading, what would eventually happen is that you would kill one sector of the economy because carbon would be too expensive in that sector. And it's too blunt an instrument, simply carbon trading on its own. That is why we use in policy development, and forgive me, but I've done this in government, on government's behalf, on secondment, in government, delivering policy papers. It is, and policy mechanisms. You can't rely on one single policy instrument. You have to rely on a portfolio of instruments.
From one slightly different angle. If the inspectors came to the conclusion that government has available through the UK ETS and Corsia and the other legal mechanisms that it may take to ensure that aviation met or came within the 6th carbon budget and later carbon budgets, if they came to that conclusion, that would satisfy, wouldn't it, your test of whether there is a material impact on government's ability to meet its carbon obligations.
In that case, where we're heading is...
No, not where we're heading. If the inspectors come to the
all right,
conclusion...
if I was in my old job advising government...
No,
inside
not
those
interested
areas,
in
from
your
my point
old
of view.
job.
It's getting a bit late. So can we please focus on what the question was? I actually wrote the question down pretty well verbatim, and I'm sure Mr. Humphries could read it out again. So can we really hone in on the question? It's a hypothetical, I know, and it may be a legalistic hypothetical. That's what Mr. Humphries does. But
It's very fair.
let's hone in on the question.
Do you want me to say again?
Do you want to come back again?
You know, on the assumption that the inspectors come to the conclusion that government has available to it through the ETS, Corsia, such other measures as they may take, the ability to control aviation emissions within the carbon budgets, or to be consistent with the carbon budgets, we would have satisfied your test of significance, whether there is a material effect on the government's ability to meet its carbon obligations.
Then there's every chance that you will get a consent, but it won't get built.
Well, I mean, there might be other things that the inspectors would take into account other than carbon, but are you saying, yes, on your test for carbon, we would have met that test? I just want to be clear on it,
Well,
Dr. Hinnells.
You could theoretically deliver carbon saving that way. But I don't think the government's identified the mechanisms to do it.
As far as non-aviation emissions are concerned, buildings and ground operations, you know, the scope 1s and electricity, those sorts of things, scope 2, there's no challenge to the assessment results. I mean, how much carbon we've calculated, I don't think.
No. Let's keep it simple. No.
Okay, the draft CCCAP, which would be subject to planning condition, has targets in it for operations being carbon net neutral, net zero, and the whole airport net zero, those are, I think you would agree, appropriate targets for the airport's own operations.
Yes.
The proposal is that the document obviously would be approved under the condition, but there would be the ability to review and update it from time to time. You probably endorse that as being appropriate.
I would, and I would actually go as far as to say that's really helpful.
Thank you. Thank you. In broad terms, I think the CCAP is, you welcome that. I mean, you know, maybe there's work to be done, it's a draft, but you welcome it as a document.
I do, yes.
As far as surface access is concerned, obviously this is not controlled by the airport, it's influenced. Again, as far as the ESA assessment results are concerned, those are not challenged. You agree with the amount of carbon we've assessed? Yep.
Yes.
We have, in fact, we've had since 2020 an offsetting obligation. Now, of course, I understand that offsetting surface access emissions, you know, is not considered the ultimate and long-term solution, but as an interim solution and moving towards the airport's carbon neutral target, it's again, I think, something you welcome.
It's something that's helpful given the difficulty with public transport that the airport has. So yes.
As far as mode share targets are concerned, we discussed that last week. I don't think I need to take you through that. And then the last couple of points, you have a section where you talk about future constraints and benefits. As far as forecasts are concerned, air traffic forecasts, obviously those were discussed during the second week of the inquiry. We did discuss carbon pricing, Monte Carlo modelling with Mr. Foley and indeed others and sensitivities around carbon prices. That's not, I think, a matter for you, is it? That's, you're not the forecaster.
Exactly.
And ditto socioeconomic benefits based on those forecasts, that I cross-examined Mr. Ciro on that. That's not for you either, is it?
No, but Mr. Ciro and I have talked about the implications of last week's carbon values paper, and there's more to be written on that, and we'll submit it in due course.
That's the point where the inspectors have asked for some separate notes by, I think it was the 24th, and
Indeed.
Parties will be putting things in. Dr. Hinnells, thank you. We've taken a long time. I know it's tiring. It's tiring for me as well, believe me. But thank you very much. Thank you.
Thank you.
Right. Yeah, thank you both very much. And we'll come back, obviously, tomorrow with half an hour's worth or thereabouts of re-examination, and then obviously move on to the next range of witnesses, this time from BAAN. Anybody got any late housekeeping matters? You did, didn't you? Yeah, yes.
At the beginning of the inquiry, we gave the feedback on the overall list of conditions, and then we subsequently had those little sessions. Well, we've had the one on noise, air quality. We're going to feedback again, but all we've got is the highway conditions. Can we get the wherever we are at the moment? And I think you indicated to me, naturally, there's been a bit of progress on chopping down the number of conditions. Can we, wherever we're at, can we get that to the inquiry in the next few days? The overall list as things stand.
I'm sure we can do that. So yeah. I'm not quite sure which side the list is with, but we'll discuss it and make sure you get it wherever
we know
it is.
It's somewhere. It's a game of tennis, but we just want to have the ball for a bit.
Yeah, sure.
I like that. Right, okay. Thank you all very much indeed for persevering on this quite warm day. We'll resume at 9:30 tomorrow morning.